let's say your car accident case does not settle in the pre-litigation stage. You go through treatment, we gather your records, we prepare a comprehensive settlement demand. We demand to the insurance companies based on a statute, CCP 999, policy limit settlement demand, we give them 30 days and they don't pay up. We're going to recommend that we file a lawsuit against them immediately. And we often get asked, what's the process of a lawsuit? What am I in for? And typically it's this: the attorneys are going to have to figure out who are potential defendants in the case. So if it's a car accident, driver, registered owner, typically, if an employer is involved in the case or a company is involved in the case, we're going to want to name all those individuals, all those entities that bear some responsibility. We file a lawsuit in the appropriate courthouse. We have our private investigators locate all the named defendants, and we have to serve them with the lawsuit. It's called effectuating service of summons and complaint. That process could take time because we need to locate people. They may be out of state, they may be in a different venue now, they may be in a different country. So until those individuals are served, they're not going to know that they've been named in a lawsuit to respond to it. Fast forward, let's say we've served everybody. They typically have 30 days to file what's called a responsive pleading. Typically in our cases, we see what's called answers, where the lawyers for the defendants will file a response answering the complaint. Once that happens, as to all defendants, the case becomes at issue. It's live now, meaning we can do our thing and litigate the case. The case enters into what's called discovery. It's basically a fact-finding time for all the litigants and the lawyers to get written questions served onto the opposing party, get their responses, get their documents, get their side of the story, then notice depositions. A deposition is an oral interview, essentially under oath, where the attorneys, the witness, the deponent, a court reporter get into a meeting, a conference, a Zoom meeting, what have you, and the attorneys ask them questions. What happened? How were you involved, etc. Fact-finding. During that process, we can identify other potential defendants. We may not know that the person who was driving the car was in the course and scope of their employment with their employer. That raises a vicarious liability argument against a company, for example. We bring them in the case. Then the process starts over as to that defendant. But once this initial discovery phase is done, where we've asked questions in writing, we've received deposition testimony, the insurance company then is likely going to notice what's called an independent medical examination. We refer to it as a DME, defense medical exam. They will hire an expert, an independent doctor that they pay tens of thousands of dollars to give opinions, typically to undermine the injuries of our clients, to give opinions that the clients were not as badly hurt, that the medical bills were too high, that the treatment wasn't necessary, or what have you. They're basically a hired gun for the insurance company. They want to get up there in a suit and tie and say, I'm Dr. So-and-so, and my opinion is this person wasn't injured. They're biased. We identify that and we expose that if the case goes to a trial. But after this medical examination process, typically we've already identified what the strengths and weaknesses are in the case. Sometimes cases get resolved by way of private mediation, where all parties agree and stipulate to submit the case to a mediation, where we hire either a retired judge or a very experienced mediator who had practiced law in this area and that individual assists the parties in resolving a case. If that doesn't happen, we're pushing the case all the way. It'll get to what's called expert discovery, CCP section 2034. The attorneys will demand that both sides exchange expert information. Then expert discovery will go underway, where we will now take depositions of retained doctors, retained engineers, biomechanical type experts, accident reconstructionists, and what have you, because we want to know what the other side's experts are going to say to a trial in front of a jury if it gets there. And this is very close to our trial date. Sometimes cases will settle at the courthouse steps at the eve of trial. Sometimes they won't. And if they don't, we answer ready and willing to put the case before a jury so that we can ensure justice is served for our clients.